This silent video shows the moments that led up to the death of immigration attorney Jason Cleereman in September of 2020. Prosecutors argued it was a case of road rage that the defendant, Theodore Edgecomb, escalated to its deadly end.
He has a gun. He withdraws it and he shoots him in the head. He started a fist fight and then he brought a gun to it.
Edgecomb's attorneys argued their client acted in self-defense after he was allegedly assaulted, an incident that occurred off camera a few blocks away.
The defendant is in custody. He's seated on the witness stand. He's in street clothes. He's in a suit.
But Edgecomb's own testimony at trial was not consistent with self-defense.
When he did take that large step towards me, it was just a reaction, and the gun just went off.
He testified the shooting was accidental. He said he was on his bicycle when he claims he was sideswiped by the Cleereman's car. He testified he was angry and punched Jason Cleereman in response. But when the Cleeremans followed him and confronted him, he said he feared for his life.
I never intended to hurt or harm or endanger anyone upon that day. I wish it never transpired.
After several days of testimony on January 26, 2022, a jury agreed the killing was not intentional.
We, the jury, find the defendant, Theodore Edgecomb, guilty of first-degree reckless homicide.
And convicted Edgecomb on the lesser charge of first-degree reckless homicide. Edgecomb's family and supporters expressed outrage over the verdict.
They're devastated. It's a nightmare. I thought 100% it was going to be not guilty. And when the jurors didn't see things the way that we saw it, we were just devastated.
Well, today, Theodore Edgecomb appeared in court for his sentencing hearing. He was facing up to 60 years in prison. Well, Judge David Borowski addressed the defendant before handing down his sentence.
And your testimony, which the jury clearly rejected, and the jury made their decision that this was not self-defense, was not particularly credible. To say that, and you said it repeatedly on the stand, the gun just went off, when what the testimony was from multiple eyewitnesses was that you pulled up your hand and went like this, right at the forehead of the victim, and shot the victim almost directly between the eyes. That's not an accident. That's not a gun just going off. That's you brandishing a weapon and pointing it at someone's temple. Obviously, the defendant has a right to a trial. He exercised his right to a trial. The jury made a decision. But Mr. Edgecomb, you engaged in incredibly bad decision-making. You did not need to pull out a gun, and you certainly did not need to pull the trigger. Having said that, I'm sentencing the defendant as follows, largely following the state's recommendation: 25 years of initial confinement, 12 years of extended supervision. That's on count one. That is the absolute minimum required to punish the defendant, to incarcerate him, to send a deterrent message to this community. 25 years of initial confinement, 12 years of extended supervision. This was a homicide. That sentence is consecutive to the end of the case, consecutive to any other sentence. And count two, which is the bail jumping, I'm sentencing the defendant to a total of 4 years, 2 years of initial confinement, 2 years of extended supervision. That sentence is concurrent to count one, concurrent to count three, and concurrent to any other sentence. And count three, which is the misdemeanor bail jumping, I'm sentencing the defendant to 6 months in the House of Corrections or in jail. That sentence is concurrent to count two and concurrent to count one. It's the court's specific intent that the defendant serves 25 years of initial confinement, 12 years of extended supervision.
All right, let's bring in the think tank to discuss. Still with me, former senior homicide prosecutor Bernardo Villalona. Criminal defense attorney Ian Freeman and criminal defense attorney Michael Bixson. Michael, I want to begin with you. Want to get your thoughts. Was this a just sentence?
It's tough to say. When I viewed the footage and when I saw, what the discovery was available to the public, to me that seemed like intentional and not reckless homicide. I'm a little bit surprised by the jury's verdict in this case, but that's the nature of a jury's verdict. You just never really know what's going to come out of it. I mean, I've seen cases where there is a mountain of evidence for one side and they go the other way entirely. So, can anything happen? Yes, and it certainly does look like that happened in this case because to me it is a very surprising verdict.
What was even more surprising, Bernardo, was that the prosecution didn't ask for more. Even the judge said it himself. He was surprised that they didn't ask for more years, and he went along with their recommendation. The thing he seemed to harp on was the proactivity of the defendant, the fact that he went over and decided to punch the man initially, which then led to a series of events which ended up with the shooting. Your thoughts on this sentence?
So the judge definitely had a lot to say in this case, because I would say I thought he was going to give him even more time because the way he presided over the trial and the way that he will go off at the defense attorney, I found was a bit disrespectful. But in terms of the sentencing itself, there's a couple things that this judge said that stands out to me. Number one, he was upset with the prosecutor for asking for a low sentence and told the prosecutor that. Secondly, he said to the defendant, like, this was no accident. The jury found that you did not act in self-defense. And quite honestly, this judge said, I did not find you credible. There was no bruising or, anything wrong with the bike to corroborate the story that he was sideswiped. Third, the judge went in and said, this was the most diverse jury I've ever seen sit in a trial during my history as presiding as a judge. So I honestly think this judge wanted to sentence Mr. Edgecomb to a lot more time than what was requested by the prosecution. But because he had to go with what the prosecution said and didn't want to seem that he was penalizing Edgecomb for going to trial, he went with the prosecution's recommendation.
Yeah, I could not agree more. He even looked angry that he couldn't sentence him to more. That's the way I sort of read it. Ian Freeman, love to get your thoughts.
I'm going to be very, very short on this one. The jury spoke on this offense. The sentence was within the range, and therefore it's a fair sentence. I mean, there's really no more and no less to say on this one. It fit what the jury found.
Fair enough. I mean, I have to agree. I mean, at the end of the day, based on what the jury found, it certainly was a just sentence in that sense. And I was wondering, Michael Bixson, if he would take into account at all, as I mentioned earlier, you talked about the proactivity of the defendant. I was wondering if he would take into account the proactivity of the victim as well. The victim got out of the car, went after him. Had he not done that, obviously this wouldn't have happened. And I thought initially maybe he had taken that into account by not sentencing him to a higher sentence, but I think he felt more constrained by what the prosecution recommended, more so than I think, had they not recommended that and recommended more, he would have been very comfortable recommending him for more time.
I agree. I mean, do I see that did the victim actually take some steps in this case that could have contributed to, an arguable self-defense? Yes, he did. But they were so minimal that I can't imagine that there really was any real credibility to the self-defense claim in this case. And for the reason, I don't really think that the judge was sort of pushing him for that. And I certainly don't think that, the judge was going to go beyond what the state recommended because, he didn't want to sort of mix up the sentence and make it look like he was actually punishing him for just going to trial. I mean, I do see that sometimes, and I certainly appreciate it when a judge doesn't punish someone for actually exercising the right to a trial. And it looks like that happened in this case.
Bernardo Villolona, I also made note of the fact that he talked about this being the most diverse jury he's ever had while sitting in Wisconsin. And of course, I think that was a reference to the fact that there were some claims that people were saying he would not have been charged if he were white. If this were different, things would, if the races were switched, there would have been a very different outcome. I want to get your thoughts on that idea. We had a case recently with Curtis Reeves out in Florida, the movie Popcorn murder trial. Self-defense claim there, different circumstances, different folks involved. But again, people point to that a lot online saying, had it been a very different circumstance here, we would have had a very different result.
Well, the different circumstances having the victim be black and the defendant be Caucasian. So that's what people really are talking about. What would be will this be a different conversation? Would he have ever been charged? Would this have gotten so far? Would this have been charged as an intentional homicide? So many questions. But in the end, look, a jury heard the evidence, they heard the facts, and he had a diverse jury. And that same diverse jury, just like the judge said, a jury of his peers found him not to be credible and found him to be guilty of reckless homicide.
Yep, and the judge did what he had to do. 25 years, 12 years extended supervision for Theodore Edgecomb. All right, so that's the end of that. Of course, there'll be appeals, but we'll keep you updated on anything like that. All right, Think Tank, stand by, please. We do have to take a quick break. But here's a look at what's still ahead on Closing Arguments. In Morristown, New Jersey, Michael Barrasone is accused of the attempted murder of 2 people. Tonight, his lawyer speaks to Court TV.
At the time of the shooting, he did not know what he was doing was wrong.
Plus, Amber Heard's Washington Post op-ed is the centerpiece of Johnny Depp's lawsuit against her. So tonight we're asking you, the 13th juror, should Amber Heard be protected by the First Amendment?